In the morning, presented by First Commonwealth Bank, WCCS 101.1 FM and AM 1160. And Marshall Chriswell is here for Marshall Law. This radio program is intended to be for informational purposes only and does not constitute legal advice. The law constantly changes. The information may not be complete or correct depending on the date and your particular legal problem. Each legal problem depends on its individual facts, and different jurisdictions have different laws and regulations. Because of those differences, you should not act or rely on any information in this segment without seeking the advice of a competent attorney licensed to practice law in your jurisdiction for your particular problem. Marshall Chriswell is one of those, and he's with us this morning. Good morning.
Good morning.
Happy June to you.
Yeah, you as well. It's feeling kind of Juney outside.
Yeah, it's feeling kind of April-y outside this morning.
True.
Hey, I wanted to get into this topic with you today, and it comes at your suggestion, too, because I think it's a really good one. And that is, you are the subject of a lawsuit. You either have sued or have been sued, and now it's time to get ready. And so you're meeting with your attorney, you're forming strategies and gathering information. Could you take me through that process a little bit? What happens in those days in preparation for answering a lawsuit or filing one?
Yeah, and as any attorney knows, preparation, the amount of time you spend preparing and how well you prepare yourself and your client is just as important as what happens whenever you get into the courtroom or the deposition or the mediation or whatever the particular proceeding may be. The preparation is absolutely key. So I put a lot of time and effort into really preparing my clients for what's coming up. And the first big thing is, okay, what is the purpose and scope of the proceeding that we're going into? And I find in talking to clients, sometimes they really, don't have a clear understanding of what the purpose of the proceeding is, what's going to happen, and what our goals are, what we need to get out of it. So that's the first thing, just overarching, big picture stuff. Okay, this is a mediation as opposed to a trial, and how is that going to go, and what do we expect? And then more detailed things like what should you wear, things like that, and you'd be surprised both ends of the spectrum. Some clients are more informal, and they may show up in jeans and a t-shirt if you don't kind of say, all right, this is a formal court proceeding, and you need to wear something at least that would look like business casual.
Somebody who probably has never been in a courtroom before. They've only experienced courtrooms by watching them on TV.
Absolutely. And the other end of the spectrum is sometimes folks say, all right, well, I'm going to wear my three-piece suit, and sometimes you don't need to do that either, just depending on the nature of the proceeding. So there are those practical things. And also, okay, if this is a trial or a hearing, how do you conduct yourself? So you're going to be sitting next to me at counsel table. The client is. What should you do when you're there? And it's usually things like, what shouldn't you do? All right. You shouldn't show visible emotional reactions to the testimony that's being given in court. Things like that. If someone's sitting on the stand and tells a bald-faced lie, you shouldn't laugh or yell or do any. You've got to.
Common reaction is to smirk.
Yeah, to smirk. Yeah. And believe me, courtrooms are set up. Why does the judge sit where he sits on a high bench overlooking everything? Because he or she can see everything that's going on, and you don't want to make a bad impression. So, those kinds of things. Instructions as far as, well, what if you have questions during the proceeding? If someone's testifying and you want to tell me something or ask me something, I usually give my clients a pad and a piece of paper. And say, okay, or pad and a pen, and say, all right, if you have questions, write them down. And at a moment when I can look at them, I'll do that because I need to be concentrating on what's going on. So, all of those kinds of things, just just logistical things are really important.
Yeah, I used the word lawsuit. I should have said litigation, because there's so much more than just lawsuits that attorneys are involved in when a case actually gets to court. And I think that's probably something people don't understand either, is that many cases are not going to make it into the courtroom, are they?
Not going to make it to trial. And you're right, sometimes not even a hearing. We've talked before about the statistics. It's somewhere north of 90% of cases settle. Very few cases actually make it to trial. And that's because the system is designed to push parties to settle. And so with that in mind, there are proceedings that can take place up to trial, such as mediations. In every child custody case in Pennsylvania, you're required to go through, depending on the county, a mediation or a conciliation process where the parties get together with someone employed by the court and talk about settlement and see if they can reach an agreement. And when you're preparing for a proceeding like that, this is not necessarily. It's still the legal system is an adversarial process, but this is a moment for everybody to take a breath and say, okay, can we come to a resolution here? And so, you got to prepare the clients going into that. To go into it, I usually, want people to go into that with an open mind, because I find that a lot of litigants think, okay, this mediation thing's a waste of time. The court's just forcing us to do it. There's no way we're actually going to settle this case. We're going to trial. And in reality, a lot of cases do settle at mediation. It's good to approach it with an open mind and and one of the things that we talk about in our preparation sessions is, exactly what are our goals? What's our initial proposal going to be? What's our bottom line going to be? And if we can't get a deal that is palatable and acceptable to us, we're going to walk away. But going into it with a clear understanding of what we're doing.
You touched on this a couple of moments ago, but I want to get back to it a little bit, and it has to do with the old feeling that an attorney who was surprised in the courtroom is an attorney who was unprepared in the courtroom. But a client who's not really experienced in courtroom procedures and everything might hear something that leads them in a way that they didn't really consider that the case might go, and they're surprised by the direction that a case might be taking and the testimony might be going. Is there a period of, I don't want to say coaching, but is there a period of time where you have to prepare them to say, you're going to hear some things in there in the courtroom that you really didn't expect to hear, and I need you to react in the proper way to that?
Oh, absolutely. In just about every hearing or trial, something is going to be surprising to both the client and myself, because you don't know 100% of the facts until you get into the courtroom. So definitely, like we talked about, is making sure to control your emotions and have to understand that while something may surprise you and it may have been unexpected to us, that there's a plan for dealing with that. We've got to stick to our overall strategy. And that's why the preparation is so important. And letting the client understand. I think that sometimes attorneys take for granted that their client understands all of the arguments that are being made, understands the broad themes of the case that we're trying to convey to the court. Really, attorneys need to sit with their client and explain those things, because once they understand, all right, these are the important points that we need to drive home, some of that other little stuff becomes just minutia. Some of those surprising things you're talking about can be a very small detail in the case that the client might think is super hugely important. Oh my gosh, that I can't believe that witness said that the sky was blue that day, but it doesn't matter in the overall case.
I would assume as well that attorneys have to not take for granted that their client has told them everything that they need to know going in, and the other side comes up with something that you could easily have prepared for as the attorney, but you didn't know about it until you heard it in the courtroom, and then you got to turn to the client and say, it would have been good to know this before.
and that happens. That happens. One way to try to stem that a little bit, when I prepare with my clients, I take them through the exact questions that I'm going to be asking them on the witness stand. So I would hit on every single point that we're going to talk about. And then also, I try to play the part of opposing counsel, and I don't know exactly what's going to be asked on cross-examination, but I can take a pretty good guess.
Mm-hmm.
I can, what would I, if I were on the other side, what would I ask on cross? And so then I ask those questions kind of in the manner that that opposing counsel is going to ask them, and that can bring out a lot of different subjects that maybe the client, and it's not that your client, sometimes they're not forthcoming, I guess, but a lot of times it's just they have trouble discerning between what is important and relevant and what isn't.
Mm-hmm.
And sometimes a fact that a client thinks, this wasn't a big deal, turns out to be a big deal. So you want to try to get to all that stuff.
Yeah, and I would assume that sometimes, when they understand that you got to tell everything, that the idea of attorney-client privilege finally kicks in their head, and they've learned that they can trust their own attorney, because
Right.
This is probably something that maybe they have not really told anyone, but all of a sudden it becomes germane to a case, and you say, if you don't trust me, how can I help you?
Right, absolutely. And that's something that we talk about from our first meeting generally, is attorney-client privilege, and how important it is that I get. Not only is it important that I do my job for them because they hired me, but the client has responsibilities too, and they need to fully cooperate with me, or I can't do my job properly.
Yeah. Okay. Well, he's attorney Marshall Chriswell. This is an interesting topic. We could spend a little more time on this next time, or sometime down the road.
Sounds good.
Meanwhile, folks want to get in touch with you, learn more. What need they to do?
I'm in the Atrium Building in downtown Indiana. You can call me at 465-5826. or find me online at westernpalawyer.com.
Very good. Thank you.
Thanks.
He's attorney Marshall Chriswell. We do this every 2 weeks or so. It is called Marshall.